worked in an international law firm, did consulting for international organizations, so I'm a traditional lawyer in that sense. So what was it for me that conditioned my critical response? So my personal inspiration comes from, or professional one, comes from my work on complicity in international criminal law, when I studied why people assist in mass criminality. So not the ones who pull the trigger of a gun, but the ones who perhaps guard the prisoners before they're being killed. So what kind of culpability they have. And when I was doing my PhD on this topic, I read, for instance, Stanley Milgram, who I know many of you know in this room, whose experiments you know, obedience to authority. So I assume everyone knows, but just very briefly, he examined how people respond and what kind of pain they can inflict on another human being when they're being told that it's okay by people in white coats, by people perceived as authority. And what Stanley Milgram showed is that people can go pretty far, like really far, and a big percentage of people. And it doesn't depend on their social status or class, etc. It's 50-60% can go really, really far. So that work shocked me. But how we explain it in international criminal law? We say, well, it's because the circumstances are exceptional. It's because there is societal disintegration, because there is civil war, because there is unrest. So people's normal expectations, they disintegrate. So what we say when I teach international criminal law, I'm saying, well, it's about collective criminality, but yeah, in international criminal law, we expect people to be exceptional, not to follow unlawful orders. They have to be exceptional. So yes, we try these people accused of mass atrocities, but we have to have compassion for them because they're in extreme circumstances of societal unrest. So this is the mindset. So I'm saying, yeah, it takes a lot of courage to be disobedient when you're given an order. But the context is of international criminal law. But I have this mindset also when something coercive is happening in peaceful times. So that really inspired partially my response and my criticism, which was more private, to be fair. I'm not working directly on this topic. Then the other part is Hannah Arendt's work, and again, I'm pretty sure a lot of people in this room are even more familiar with her work and studied it in more depth. I studied it as a lawyer. The origins of totalitarianism, and specifically how we talk a lot about fundamental rights as lawyers, as human rights lawyers, but it's still not a very trendy topic to talk about access to rights. What does it mean to grant someone access to rights? And Hannah Arendt talks about interwar period and how people were stripped of their nationality and then they could not access the rights altogether. And she says, well, it's a bit hypocritical that we are focusing so much on these specific rights, but there are big groups of minorities, but big groups who are stripped of even the ability to claim these rights. And I saw some parallel with COVID measures because in a way, and this is my general framing of legal response to COVID measures, it's missing the forest for the trees. So we answer here a little bit there, and we do this proportionality test, which Muriel has already mentioned in the beginning, and I will go over them. But the general idea is that we are not looking at the whole picture necessarily as lawyers, but we focus on these specific rights, but we don't necessarily talk about people's ability to access these rights. And that links to the question of consent that we discussed before. Like, did I generally consent to this whole transformation of my lived reality? Probably not. And the last bit which inspires my mindset personally at this point of my journey, both academic and personal, I'm working a lot on self-reflexivity in international law. So thinking of law not just being out there, it's a system of norms and institutions, and as lawyers we just need to understand if custom exists, if the treaty is interpreted in this way. It's part of it, but it's also who I am as a lawyer, as a human being, that determines how I interpret the law. So we need both, and because of the times of uncertainty, more and more international lawyers are actually starting to open to this kind of approach. So it's asking themselves where they stand, but not necessarily in the ideological way, but more like what are my beliefs that shape my application of law. So we are actually ripe in international law to enter these domains. but we're still looking for the language. So I'm really looking forward to the panel on the language, because we miss the language of self-reflexivity, because it's still seen a bit as a hippie law or therapeutic law, which it's not actually. It's really hardcore law, which we need to redesign post-World War II. We need another system, because the post-World War II system of UN, it's great for that time, but for this time it may not be super useful. So we need to be more creative. Now, another big element, which I will say before I go to legal analysis, but superficial one, but still some legal analysis. Another big framing that I use is on legitimacy. I thought a lot about legitimacy in the past. I use the work of Christopher Thomas, Uses and Abuses of Legitimacy. It's from, I don't know when, but this is the name of the article, I just don't have it in front of me. The best analysis of legitimacy I've read. It's in the Oxford Journal of Legal Studies. So he gives three definitions of legitimacy: moral, legal, and social legitimacy. Social legitimacy is societal consensus to be bound, so societal acceptance to be bound by certain norms based in sociological considerations, so it's consensus based. Moral legitimacy, it's a belief that this is a valid rule. Belief can be religious, do not kill. It can be secular, but like we talked about science as religion, so it's a belief. And then legal legitimacy is perhaps what lawyers are most familiar with, the validity of a legal norm, that it has been passed by the parliament or by the case decided by the judges, so there needs to be certain adherence to the process of legal production. So this is legal legitimacy. So Thomas argues that we need all three elements for something to be convincing as a legal norm. So what we have heard in the morning, I was comparing it to this whole legitimacy definition. There have been conditions that were created to persuade society that it's a valid scientific consensus, that there is urgency. So creating this moral and social legitimacy. And then there were laws, sometimes executive orders passed in a certain way. It was expedited, but still they were passed by the governments. So in a sense, the formal criteria of legitimacy to some extent were met, all three. Some of us did not really enter the consensus in terms of social or moral legitimacy, but a lot of people did in society because of, one can say, propaganda. The others will say, no, it was a valid scientific discussion, but yes, that was perhaps why a lot of lawyers felt convinced by the measures. Now, I did a bit of research as a lawyer, just to give you the mindset as to the responses by different fields of law to COVID measures and whether I find them convincing. And I want to apologize in advance because I know that my lawyer colleagues did a lot of work and research, so I'm going to give you a superficial summary of the judgment. So I'm not going to do justice to the nuances of judicial reasoning. For that we really need a lot more time and need to explore it. But how would a lawyer approach this whole issue? International lawyer. So we have different fields of law that are triggered. We have EU law, we have domestic constitutional law, we have human rights law, and we have international law, state responsibility, and international criminal law also. Very briefly for each one, how one would analyze it. So if we talk about law of state responsibility, we don't have any pending cases to the International Court of Justice. We don't have. So basically, there needs to be global consensus, and some states need to push for an advisory opinion by the International Court of Justice to rule on the legality of the measures, on the WHO response, whether it was sufficiently clear, etc. So we need some kind of pushing from some states or civil society organizations. We don't have it. But if we had it, the main problem would be that the states will claim force majeure. So the states, under articles on state responsibility, Article 23, they can say we can commit wrongful acts if there's force majeure, and force majeure are circumstances precluding wrongfulness. So under this article, if there is unforeseen event or irresistible force that is beyond state control, the state is absolved of responsibility. So beyond state control, I don't know if we have agreement here that it was beyond state control, but the general narrative, it was beyond state control. So we don't have anything now brewing at the level of state responsibility, but we have climate change decision, very recent, very good one, advisory opinion on climate change, saying states are responsible for mitigating climate change. So there is precedent, but not for COVID measures, but maybe 20 years down the road, who knows? International criminal law. Crimes against humanity can be the paradigm, potentially, but what we need for crimes against humanity, widespread or systematic attack against civilian population, doesn't need to be weapons, so it can be anything, maybe, part of organizational or state policy, maybe, must be of sufficient gravity, the measure, in the interest of justice to be admitted to the ICC. So, is it in the interest of justice or not? I would say probably not, given the current, not from my perspective, but from the perspective of international lawyers, probably not in the interest of justice. So that's admissibility criteria. The underlying acts so we need to meet the umbrella, what I mentioned, and we need underlying acts. Underlying acts for crime against humanity, I found imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law. There is also 7.1k, which is other inhumane acts. Will the judges think that the situation was grave enough to qualify for that? I don't think so, honestly. I don't think it reaches the threshold of gravity. Systematic, yes, or widespread, but it's not sufficient gravity, it's not in the interest of justice, and probably imprisonment and severe deprivation is reserved for something less brutal, even though what we discuss here, it is brutal also, so I don't have an answer really for that. There is a person working on invisible atrocities, Randall DeFalco, incredible scholar of international criminal law, who says we need to rethink international criminal law because we are so fascinated with genocide and really fascinated in this way that we pay a lot of attention to the most spectacular ones that shock our consciousness, but we are a bit blind to forced labor, child labor, domestic violence, all sorts of slow violence to the environment, that we actually need to have a paradigm of international criminal law which is broader and which is not so focused on this moment and the shocking atrocities. That is also important, but we need to broaden. So maybe with his scholarship and people like him, we can expand. Now the most two difficult paradigms, and I know I don't have much time, probably. How much time I have?
3-4 more minutes.
Perfect. So just very briefly, two paradigms which are most applicable. EU law, have there been complaints? Yes. The the Court of Justice of the European Union ruled on some measures, like nurses resisting vaccination in Italy, freedom of movement obstacles, under Article 21 of the Treaty of the Functioning of the European Union, so the EU citizens are guaranteed freedom of movement, so what about the COVID passes? So basically the main reasoning, and now I'm really oversimplifying it, but the main reasoning, what the court says, it is also apparent from the court's case law that if there is uncertainty as to the existence or extent of risks to human health, a member state must be able, under the precautionary principle, to take protective measures without having to wait until the reality of those risks becomes fully apparent. So precautionary measures, also Article 168 of the Treaty on the Functioning of the European Union, health measures are the domain of individual states, so either the cases are inadmissible because the member states are dealing with it, or precautionary principle and all that comes with it. Last one, which I think is the most relevant for this situation. I'm not analyzing domestic constitutional law, but it's similar to human rights law. So the European Court of Human Rights, which is here in Europe, the general approach to the cases, inadmissible because the person should first go to their domestic courts and they didn't do it for whatever reasons. Lack of direct victim status, some professors complained, law professors complained, well, you were not directly affected, you're just making an abstract argument. Derogations under Article 15 of the European Convention on Human Rights, basically it's the same as state responsibility, same logic. When there's some kind of obligations in times of war or other public emergency, the state can derogate from basic human rights guarantees, and they consider it to be public emergency. And then there are exceptions for what I call, it's not a legal term, comorbidity. So if there is immigration law involved, so immigrant status and the person is detained, or there is imprisonment and the person is not extradited because of COVID measures, in these cases the court actually declares the violation of a certain provision, like the right not to be tortured, prohibition on arbitrary detention, so if the person was detained, but the person was already in a very vulnerable situation. And this is also the position of UN human rights bodies. What I looked how they approach it, it's like, yeah, let's try not to exacerbate racism or violence against women, so it's always connected to a certain vulnerability status, but not the whole measure. And yeah, just I will say that most of the times the court said it's inadmissible for the reasons I found out, I told you before. Last point, I will just quote from the recent case Pasquinelli and others versus San Marino 2024, European Court of Human Rights, 26 applicants, all healthcare workers. They refused to be vaccinated against COVID, and they claimed the violation of Article 8, right to private life, which is a traditional article for this kind of decisions. So the court said San Marino did not violate their right to private life because the legislature has been justified. Measures were designed with the legitimate aim of protecting the health of the population in general, including the applicants themselves, so a patronizing attitude, and the rights and freedoms of others, and the measures have been proportionate to the aims pursued and did not exceed the wide discretion, margin of appreciation of healthcare policy matters afforded to the states. So I will just conclude with probably what everyone knows, the proportionality analysis, which is applied by human rights law and also constitutional law. It has to be in accordance with the law. Yes, we have a law. It has to be necessary in the democratic society, and it has to be proportionate to the interest. But this is a subjective assessment. So this is the main point, that it is all subjective. I have something to add, but I will add it during the Q&A. Thank you.
Thank you.
Okay, our next speaker is Professor Klaus Kraemer. Did I pronounce the surname well?
Yes, wonderful.
Okay. Professor of sociology since 2010, field economic sociology, but has an interest in sociology of crisis. Professor, the floor is yours.
Okay. Thank you very much for the introduction. Dear Muriel, thank you very much for the friendly invitation. Today I want to present some theoretical arguments in order to better understand the COVID crisis as a social crisis. Especially I want to talk about the cultural conditions, the epistemic consequences, and the institutional dynamics during the COVID crisis, and especially from a sociological point of view. I will discuss not the natural dimension of the crisis, but especially the social side of COVID crisis. Here I follow Emil Durkheim's concept fait social. Okay, let me start. My starting point is that in democratic societies, conflicts are absolutely normal. We argue about the better argument. We write arguments, we compare evidence and counter-evidence. We balance values, we balance interests. Disputes and conflicts are not a malfunction, it is the core of democracy. But during the COVID-19 crisis, something changed. Something changed in a fundamental sense. Conflicts did not just intensify, they became indivisible. Compromise seemed impossible, doubt appeared immoral, and criticism looked irresponsible. The dispute between, for example, supporters and oppositions of the non-pharmaceutical intervention escalated even into private life. The debate collapsed, and then it is gradually fade from open debate. Why? This is my central question today. My thesis is that the conflicts during the crisis cannot be explained primarily by uncertainty, cannot be explained by ignorance, cannot be explained by irrationality, and also cannot primarily explained by emotion or panic. It was driven by a specific collective morality, and I call it a community of apprehension. This collective morality moralized risk, absolutized values, and transformed political debates into indivisible conflicts. Let me begin with a distinction. Albert Hirschman, a German-American sociologist and economist, left Germany, left Berlin 1933 and immigrated first to Paris, then over London to New York. Albert Hirschman spoke about the difference of divisible on the one hand and indivisible conflicts. Here I follow Hirschman's argument. Divisible conflicts are normal. They concern interests, resources, distribution, or positions in organizations. They follow the logic more or less. They can be negotiated, institutionally proceed, and pacified. Indivisible conflicts are different. They concern ultimate values, life, truth. They follow the logic of all or nothing, life or death. Relativizing risk, putting them into perspective, seems irresponsible. My claim is, during the pandemic, political disagreements shifted from divisible to undivisible conflicts. In indivisible conflicts, actors distinguish between friends and enemies. What is a collective morality in a sociological sense? It is a shared moral horizon. It defines what is relevant, what is dangerous, what is responsible, what is savable, and also what is not savable. It integrates inward and it excludes outward. During COVID-19, a specific collective morality emerged, a morality oriented towards the worst case. The virus was framed as an existential threat. For example, President Macron, a war against the virus, or in Germany, Chancellor Merkel, a once-in-a-century catastrophe. From this view, the pandemic is described, and this is important in my view, as a socially unstructured natural event that threatens everyone indifferently, young and old, healthy and vulnerable. Evidence and counter-evidence are not compared. This perspective eliminates, in my view, socio-epidemiological differences, ignores the strong age gradient of real risk, narrows the view to an abstract, universal and existential threat, and inflates hypothetical risk beyond empirical differentiation. The consequence of this collective morality is that the protection of life became an absolute value. And where values are absolutized, conflicts become invisible. In sociological terms, I want to follow a central argument of Max Weber that such conflicts were primarily not only emotionally but especially value rational, not simple emotionally. The value rationality is powerful, but it is rigid. It cannot compromise without losing its moral claims. This rigidity explains why conflicts became indivisible. I use for this collective morality the term community of apprehension. It is based on shared expectation of danger and fear. It creates it's a strong we group in the sense of Norbert Elias, but also discrimination and exclusion. Here's a study of Alexander Bohr from University of Copenhagen with colleagues, and he showed in this study this dynamic, and the paper is published in Nature early 2023. It was a quantitative survey in 21 countries of the EU, roundabout with over 15,000 respondents. And the study showed, in a wonderful way, I think, high levels of discriminatory attitudes towards the unvaccinated across most EU countries, and it's very interesting, exclusive Hungary and Romania. Such attitudes reached a level that is normally observed in normal times in relation to traditionally stigmatized groups such as ethnic minorities and, for example, refugees. The paradox phenomenon is that such attitudes were particularly strong not in right-wing milieux, especially, but in liberal milieux, which normally feels committed to universalistic norms and values. This shows something important in my view, because the findings can be interpreted as the social flip side of the idea of protection. That, for example, Eva Illouz describes in her last book, Explosive Emotion, as a central legitimation principle of statehood in contemporary societies. The community of apprehension is, on the one hand, value-based, particularistic community, and at the same time, an exclusionary community. What happens when risk becomes moralized? Deliberation shrinks and uncertainty becomes suspicious. This leads to, I call this phenomenon, epistemic closure. Debates, for example, debates about the proportionality of the measures like school closures, curfews, access bans, green pass, and so on were ignored, and also were ignored questions about the collateral damage, for example, psychological costs of the pandemic management, the socio-economical consequences of lockdowns and long-term social effects. Even within science, open disagreement were framed as danger. I want to give you a first example. The question of the origin of SARS-CoV-2. In the early phase of the pandemic, two hypotheses existed: a natural zoonotic spillover, and the second hypothesis, a possible laboratory accident. Instead, to verify the laboratory hypothesis, it was rapidly moralized and framed as irresponsible as conspiracy thinking. Only years later, especially in the US, the debate did reopen. This is a typical pattern of epistemic closure. I want to give you a second example for these patterns of epistemic closure: censorship and platform governance. During the pandemic, large social media platforms, often in cooperation with public authorities, removed content, flagged dissenting views, restricted visibility, shadow banning, or imposed account suspensions. Not only fringe actors were affected, but also serious heterodox scientists like the initiators of the Great American Declaration. The distinction shift not between better or weaker arguments, but between facts and non-facts or misinformation. In such a binarity framework, liberal plurality shrinks and debate narrows. The epistemic field is simplified. Closure becomes institutionalized. Another example for epistemic closure concerns data. Model scenarios, here I marked it in red, often replaced empirical prevalence studies, laboratory values, for example, data about a PCR test, were treated ex proxies for clinical disease data. Incidence dashboards became the central political indicator, but representative population data were largely absent in many countries for a long time. Under such conditions, institutional learning is blocked. This is my third step. Because learning requires the possibility that previous decisions were problematic. But if decisions were framed like there is no alternative, a revision would appear to be a moral failure. A crisis, the Corona crisis, was in my view not a normal crisis. It was, in my term, a singular crisis. In such extra-normal crisis, the normality suspends overnight. Practices, rules, habits, justifications, or epistemic beliefs. In such moments, the community of apprehension unfolds its full force. Its moral horizon does not merely shape perception, it structures institutions. In paraphrasing Max Weber, collective morality acts, as I quote Max Weber, as a cultural switchman that defines the tracks along which institutional decisions move. Epistemic closure had consequences for crisis management. The range of possible decisions narrowed, leading to a tunnel vision. A classic example of path dependency. One moment, please. 1 minute or two. It's okay. A classic example of path dependency. For example, in Austria, and a similarity in Germany. In Austria, we have 4 lockdowns and 37 weeks of school closure. In Switzerland, only 8 weeks. Curfews, mass testing without occasion. And finally, escalation, the strategy of escalation. Escalation, for example, access bans for the unvaccinated. We must talk about round about 20 million people, for example, in Germany, only in Germany, 20 million. And here in Austria, the part-time vaccination mandate. My theoretical conclusion: moral intransigence and epistemic closure reinforce one another. When it comes to life or death, then crisis management follows the logic all in, and Toby talked about yesterday, and pay any price. For example, massive fiscal interventions in the EU refinanced through extraordinary bond purchase programs from the ECB, around about 1.3 trillions in the first year. But cost-benefit considerations appear secondly, because when life is absolutized, price becomes morally irrelevant. I come to my conclusion. In such crises, institutions bind through moral self-legitimation. The crisis was not merely a crisis of health, not merely a crisis of political culture, but a crisis of institutions and self-reflection. When values become absolute, institutional reflection collapse. Learning may block even after the crisis fades. The community of apprehension is therefore not only an anomaly. It is, I think it is a recurring conflict form of modern societies in singular crisis under conditions of perceived existential threat. My last sentence: the question is not whether crises will return. I think they will. The question is what needs to be done that conflicts do not escalate, that epistemic openness is not lost, and institutions are able to learn. I want to finish with the question: what happens next? What happens next? Which further development do you accept? Thank you.
Thank you. Oh, I didn't tell you, Jovana. It's a surprise also for you. But our third speaker was supposed to be Jenny Nunes. She cannot make it because she's having a state of emergency, whatever. But she has a colleague who will speak in her place. But he's coming on at 15:50. So we have 20 minutes of discussion. Then we'll hear him and then we'll continue the discussion.
On Zoom?
Yes, it will be on Zoom.
Questions?
Yeah, thank you for the presentation on the conflicts and the epistemic closure and epistemological approach to this. And when you mentioned Albert Hirschman's name about her approach to divisible or indivisible conflict, it came to my mind that he wrote another article in which he said that there are two types of conflicts in modern societies. One is either or conflict, or more or less type of conflict. And either or is what you just described, very dangerous, value-based life or death conflict. And he argues that the modern society is able to transform either or type of conflict into a more or less type of conflict, when there are no total winners, no total losers. So that's the logic of democracy, that if I win today, I can lose tomorrow, and if you lose today, you can win tomorrow. So it is not a question, it is more like a comment. I wonder whether you remember to this, and I recommend, I think that's a splendid article by Hirschman.
Okay, should we maybe collect more, or you want to respond immediately?
Yes, a short comment. I absolutely agree with the view of Hirschman. Hirschman described a type of conflict in normal times, and in normal times it is unproblematic in most kind of conflicts that indivisible conflicts switch to divisible conflicts. But the Corona crisis was for me not a normal crisis. In modern societies, crises are absolutely normal. Economic crisis, political legitimation crisis, banking crisis, finance crisis, and so on. And from this from these types of crisis in normal times, I want to differ extraordinary crisis like Corona crisis, and this type of crisis I call it singular crisis. Other singular crises are, for example, in the European history, the crisis of July in 1914, or in Germany, the German autumn, the Deutsche Herbst in 1977, the terroristic attacks in Western Germany. And it's typical for singular crises that the switch from visible to indivisible conflicts is out of order.
Oh, thank you. My question is for Marina. I was stricken by this precautionary principle. I'm kind of intrigued by it from a legal point of view. And I'm especially thinking of a lawyer of the National Rally in France who's pegged, to win next year's election. And this lawyer has been explaining on, everywhere that he was really delighted by the COVID crisis because it gives such a good example to the National Rally of how you can pervert, so to speak, legal institutions, and how easy it is. Like, COVID was an example to him how easy it is to basically, overcome the rule of law to do whatever you want. And he's full of theories about, since COVID showed us it's enough to declare a state of emergency, and then you bypass the constitutional court. And there are several ways of dealing with that. He explained, very happily, you can either dismiss the constitutional court altogether because actually it's not constitutionally absolutely indispensable, or you can declare, like the Poles did at some point, that the constitutional court is not representative enough of the people, so just populate it with people that are representative, like lawyers that are representative of the actual people, until you have a majority, and then you can do whatever you want. So I was like, it is quite terrifying, to be honest. And I'm wondering, what can be done from a legal point of view to stop this potential and quite probable future abuse?
Wow. Wonderful question. Shall I respond right away? And as you were talking, my bracelet broke. It's interesting, so it must be a very strong issue. Yes, and that gives me an opportunity, like, by itself, I didn't touch it. Wow.
I have that power, apparently.
Wow. That gives me an opportunity to elaborate on one instrument in EU legal framework, which I think can be hopeful for this situation to address these distortions, and then maybe I will address the distortions as well separately. So there is EU framework to strengthen the rule of law from 2014. I cited in my abstract. It is a communication from EU Commission to the Parliament and Council. So it's a consultative document, but it was actually passed in response to Poland and the situation that was happening in Poland, which was perceived by EU as violating fundamental rights, etc., the rule of law. So this document is not following the judicial track, and it's pre-sanctions document. So under Article 7 of the Treaty on the EU, it's possible to sanction a member state when they're not complying with the rule of law, but before that, one can do consultations. And this legal framework explains what rule of law means here in the EU. I would love to have something like that globally, but it's at least for the EU, we have an explanation what it really means. And we also have an acknowledgement in this document of the need to look at the systemic nature of abuses, that not all abuses can be dealt with on separate individual tracks, that there needs to be some consultation at the framework level, communication to the state. So this is more for systemic issues. So we have an explanation here. One, Article 2 of the Treaty of the European Union on the European Union says that EU is founded on the values of respect for human dignity, freedom, democracy, equality, rule of law, respect for human rights, and respect for minorities. So this is the foundational provision, and then this document explains that legality means transparency, accountability, pluralistic processes, legal certainty, which doesn't cancel out ethical uncertainty. Legal certainty includes ethical uncertainty. Very important for this situation, for the conflict, for the crisis, prohibition of arbitrariness of executive powers, which I think this is where the entry point can be. A lot of the state of exception was sanctioned not even by the parliaments, was sanctioned by the governments, sometimes passed in the emergency way through the parliament, but a lot of times really a lot of corners were cut. And then, like you say, the state of exception was expanded and expanded and expanded. So basically, I see in this document from 2014, which was designed for a different case, it was only invoked in relationship to Poland, potentially we can start talking about systemic nature of abuse. Because, like you mentioned, I also think it's a misinterpretation of precautionary principle in this particular case. So the court just invokes patterns of thinking from different, even disciplines, because precautionary principle is a lot from climate change law now, that we need to take care so that the environment doesn't degrade, but it's a different context. And it's a lot from humanitarian law. So you're going to bomb this city, but you will not bomb it too much because you need to take care. But here we have a different, oversimplifying, but here we have a different context. So what you noticed is what a lot of lawyers are talking about, also with IHL, with international humanitarian law, that we are misusing legal concepts a lot to make it look like we're complying with the rule of law or certain level of legality, like also proportionality tests with the wars these days. Like armies are not following actually proportionality, they're just saying they're following it, but doesn't make any sense. So it's a common trend. And it's a bit hypocritical, I see it too. And yeah, I see the solution that I see is through this legal framework, more consultation process and more acknowledging it's systemic. It's not one-off here and it's not this particular right or that particular right, but really at the level of states. I hope I answered you to the best of my ability.
Will the rule of law survive?
Is your bracelet fixed again? I think that's the evidence.
It's from Gabon.
Oh, no.
So even like, can you imagine symbolism of that? I got it in Gabon. I hope it survives. I got big news now also from the university, so I hope everything survives, but it's strong challenges to the rule of law. I'm an idealist and an optimist. I think we need to rethink what we mean by democracy, because it's often tied together to the rule of law, and perhaps here I would disagree with some people in this room. I'm not a big proponent of democracy versus autocracy discussion, because for me it's a spectrum, and different countries violate different rights on different scales and in different contexts. So for me, democracy as a concept, I don't know if it survives. Political scientists should answer this question, not lawyers. But rule of law, I think it does survive with more self-reflexivity, which was also in the previous discussion. Thank you.
Thank you.
Toby?
Yes.
Then it was
Thank-
you, and then
Thank you for this panel, which was it's very interesting, and I feel that the shadow of Giorgio Agamben is still over this panel. The state of exception. I mean, I think so. For Marina, my question would be, you know, isn't there also a need for a historical dimension to understanding how the state of exception, which has always been used by, I mean, okay, it's historically conceived as a concept in the Nazi era. So whether we think of it as what do we think of the history of democracy authority? I mean, I would agree actually that the history of democracy always had a shadow side, which was actually in the colonial framing, which was increasingly obviously accepting autocratic. But so is there? For question one would be: is there a need for a historicisation of? You know, we're just saying, okay, state of exception, that's fine, but it's not fine. The history of it shows that it is not fine in a legal setting, and then my second, tangentially to that, you know, the framework of human rights, I find fascinating because, as I said in my talk, and as I've written about more widely, this was an extraordinarily racist and extraordinary attack on human rights. You know, kids in the Philippines were not allowed out of their homes for 18 months. I mean, it's incredible. That's just one example. So what is the legal profession got to say about this? I mean, you know, you cannot simply just ignore this. It's unbelievable. And then for Klaus, yes, I mean, really, when you said life took precedence, for me, it was actually Agamben's bare life. That's what was being financed at all costs. The bare life, you know, the survival of the organism, as opposed to the social worlds which collapse. And so my question for you is, you know, the person that comes to mind when I think of your talk, I think you're absolutely right about this as there being a kind of ethical framework which explains what happened in many ways. But the theorist that comes to mind is Thomas Kuhn for me. For me, this is like a paradigm shift. A paradigm shift, you know, and your presentation of modelling as being now more significant than clinical evidence speaks to a bit what I said yesterday about computation. Computation became the new paradigm for computer-driven models, data-driven frameworks, became a new paradigm for understanding how to treat a pandemic, and overrode a century of medical history. And that was the paradigm shift, which is, for me, I wonder what you think of that.
okay, let's collect the questions if you agree, because until the next speaker we have 6 minutes. So, question.
Thank you both for your presentations. Marina, my question to you comes from one of the last things you talked about, which is the avenue of looking at arbitrary action by states, whether it be through an actual law or by an executive order or under an existing law or whatever. My skepticism is, in that time, none of those things seemed arbitrary to 95% of people. They seemed perfectly appropriate in the conditions of a relatively unknown crisis. How can you get around that when everybody, actually many people in good faith, believed that based on the evidence they knew? Klaus, I'm wondering, because you described these singular crises where the indivisible debates can't be made divisible, they can't be managed in the normal way. Is there a general set of preconditions that creates a singular crisis? Because we clearly don't live under it all the time. You know, we have, like now, there are a lot of indivisible debates where the people who are involved on either side may think they're the end of the world, but the rest of society isn't directly affected by them. Like the debate between Trump and anti-Trump in the United States seems life and death to both sides, yet the vast majority of the population isn't directly affected in the same way that they were under COVID, where everyone's lives were directly affected and interfered with on an active basis.
Okay, thank you. And you have a question.
Sure, I'll try to be quick. So we'll take an advantage of being a non-lawyer. I have the opportunity to ask legal questions. So we have this world where it seems that the international law is collapsing. Russia is attacking Ukraine, US and Israel attacking Iran. No one cares anymore. So if I rephrase Muriel's question, well, can the EU survive this? we have some examples of EU trying to take an action against Hungary. Now, after the constitutional changes in Slovakia, it might be forced to take action against Slovakia. And then with the prospect of a national rally undoing judiciary in France, what would you as a lawyer say can the EU hold on legislatively? Or perhaps for Klaus, even when we discussed how the pandemic renewed the nation state or member state nationalism, whether any such crisis, if it were to repeat, whether the bloc can withstand it, or what it can do differently to make it less of a conflict.
Perfect. Thank you so much for coming in. I have to explain a little bit who you are, because it's kind of a bit of a surprise for the group. So Jenin was one of the lawyers of the Murphy v. Missouri law trial, which was about whether social media have a right to censor certain contents. And Jenin was supposed to speak today, but she's tied in an emergency, so you're replacing her. So thank you so much for coming for her. And could you explain a little bit first what the Murphy v. Missouri lawsuit was about?
Yeah, and I'll just explain why the name changes. When we sued, it was Missouri v. Biden, because two states, Missouri and Louisiana, brought the case, and they wanted private parties who also wanted to sue with them. So we represented four private parties, including Jay Bhattacharya, who you might have heard of, and Martin Kulldorff, who you might have heard of. They're now in the administration. But we sued for social media censorship of their messages, mainly on COVID. But the reason we sued was not because we didn't think social media could censor whatever it liked, but that the government could not make them censor whatever they liked.
Right.
So on behalf of our four clients, we brought this case to show that the censorship, and it was censorship, of messages about the origin of the COVID virus, the efficacy of lockdowns, the efficacy of cloth masks, the efficacy of the vaccine, the relative efficacy between natural immunity for people who'd had COVID and the vaccine. All of these messages were shut down, and they were shut down at the behest of the government. And most of them turned out to be true. The folks who were censored were saying the right things. Now, that was not the case. I mean, you've seen that the vaccine put microchips in your body. We didn't have anyone like that. So the case was about the government controlling social media, which particularly in America is a no-no.
So where is well, first of all, I forgot to put this in the question that I sent you, but can you tell us what was the result of the lawsuit?
I can, and I'll do it in quick stages, hopefully. So we filed in the district court, which was the lowest federal court in America, in Louisiana. And on the 4th of July, which is a big day here, the court came out with a very long opinion. He'd given us some preliminary discovery, that is, to ask the government questions and social media questions and get that information. And we took 8 depositions, including Dr. Fauci, and we put our information in for a preliminary injunction, which is the district court says, I don't know how the case is coming out, but it looks like you're going to win, so we're going to stop them while you're litigating. So he issued a very long opinion saying that this was perhaps the greatest First Amendment violation in the history of the United States outside wartime. So that was a big deal, but he stayed most of the order so an appeals court could look at it. That was the Fifth Circuit, which is like Texas and Louisiana. The federal circuits covered different states, and this is sort of Texas, Louisiana, Mississippi. Anyway, the Fifth Circuit took out some of the defendants because we sued a bunch of agencies, and they said, well, you didn't show these agencies did anything, so we're taking them out of the injunction. But otherwise, he's right. This is the biggest First Amendment violation outside wartime in American history, and we're going to enjoin it. And so the Fifth Circuit agreed. Then the government immediately took it to the Supreme Court, and we went to the Supreme Court, and there it was 6-3. They didn't find standing. And standing is the idea that in the federal courts, you have to have shown your injury. Your injury is the responsibility of those you've sued. Because social media had its own way to curate messages, the court said it didn't have enough evidence that this was the government doing this and not Twitter and Facebook and all of them doing it on its own. My own view is that's completely ridiculous, but that's what they said. The 3 justices who dissented agreed. They reached what we call the merits, meaning what really happened. And they said, once again, this was the biggest First Amendment violation in the history of the United States outside wartime. So the one thing that came out of it was that every judge who reached the merits said it was a violation by the government. And then the case went back down. It was not dismissed because what you need for standing to tell the government to stop doing something is higher than it is just to have it in court and do more research on it. And then just last month, because the government didn't want to litigate and give us any more discovery, and because it was embarrassing to them because the present administration ran against all this, they settled with us. And I'll just take 2 seconds. I'm only going to read the 4 paragraphs that I think for your crowd is the most important thing. The first thing we did is we cited the First Amendment of the United States Constitution prohibits the government from abridging freedom of speech in the press. The government agreed with us about that. Second, the parties agreed that modern technology does not alter the government's obligation to abide by the strictures of the First Amendment, meaning the internet's not different from newspapers or TV or radio. And then third, the parties also agree that government, politicians, media, academics, or anyone else applying such labels as misinformation, disinformation, or malinformation to speech does not render it constitutionally unprotected. And then finally, for these reasons, the government cannot take actions, formal or informal, directly or indirectly, except as authorized by law, to threaten social media companies with some form of punishment, i.e. an adverse legal, regulatory, or economic government sanction, unless they remove, delete, suppress, or reduce, including through altering their algorithms, posted social media content containing protected free speech. That's the meat of the order that the government agreed not to do anymore. And 3 agencies, it doesn't cover the FBI, it doesn't cover some others, but it's a huge marker that you're not supposed to be doing this when you're in the government. That just happened last month. We're still working out some last minute things like what websites, because only our clients can enforce it. It doesn't apply to everybody because it wasn't what we call a class action. So that, in a nutshell, is the result.
Well, but is it satisfactory then? Because if it doesn't apply as a principle for everyone, what prevents the government from doing it again?
That's exactly. Is it satisfactory? Well, it's satisfactory given the legal parameters that both sides have. That's why it's a consent decree and a settlement. But I think that it helps everybody for this reason. This is an order by a court covering 3 agencies. There's equal protection. What are the agencies going to say if someone else brings a suit? Oh no, the First Amendment doesn't really apply. Oh no, social media really is different. Oh, this is misinformation. Are they going to be able to do that in any court in the country if you bring a case against it? The real problem is making sure we find out that the government is doing this. The government was very transparent that they were doing this back in COVID days. It was like Jen Psaki, who's the president's press secretary, said, we're going to really crack down on these social media companies and they're going to have consequences if they don't do this. I don't know if we'll get any of those type of statements, although I think we pretty clearly get those type of statements from the president administration if they were doing it, because they don't tend to hide the ball on this stuff. But that's the more pressing concern. When will you know it's happening?
Thank you. Do you guys have any questions? No questions, so wait, I have some questions more. So do you think, thanks to this lawsuit, we find where the threshold actually lies between legitimate government communication with social media and what becomes censorship?
We came closer. So this case has really in America opened up a lot of avenues to things we didn't know was happening. So we found out that the government, the CDC, which Center of Disease Control, and some other agencies got specialized portals to the social media where they could just send social media what messages were out there that they didn't like. And so those portals have all been shut down. And the question is going to be, if they threaten like your merger, if Facebook wants to buy something and they say, well, if you don't take these down, you're not going to be able to get a merger, that's pretty clear. Any quid pro quo or threat of government denial of benefit to the social media companies is out. But one of the things that was happening here was vague threats. The White House was calling these agencies and using the portal and cursing at them and things. And government, the FBI, when the FBI shows up, people get nervous. So these type of things were happening, and it's a matter of the amount, okay? It's the matter of the amount. They were so vast in this case. When we asked the government, how many contacts do you have in social media? They gave us like 20 names. When we asked social media, they gave us like 150 names, okay? They were like all in there, battering them every day. So it's a quantum of the government pounding on, because the paradigmatic example of this in the pre-internet age was, look, if we have an agent in the Soviet Union, or we have somebody we need to get out of Iran, and the newspaper is going to publish something about what's going on in Iran or the Soviet Union, somebody from the FBI or the CIA would call up the New York Times or the Washington Post and say, can you sit on this for 3 days? And they would sit on it for 3 days till they could get the guy out. That is likely not coercion. They're likely doing it because they don't want an American killed, right? You can't really make a case about that. So sometimes there's cooperation, and that's going to be the nub here, because we all thought politically within the United States, the people who ran the social media companies would be looked upon as allies of the Democratic Party. And so we all thought that the Democratic Party, because this started under first Trump administration, but not from the White House, more from the CDC and the agencies. And then when Biden came in, it became a whole of government thing. So all we lawyers, one of whom was John Sauer, he and I did the depositions. He's now the Solicitor General of the United States. We thought we were going to find that all these companies said, oh, this is great, we can censor all these messages. They did not. They did not do that. They pushed back and said, why are you doing this? In fact, I think it was Facebook, had a British politician, pretty big deal, not Niall. Anyway, it'll come to me. But he's writing to the government, this British politician, saying, isn't this a First Amendment problem? He's pushing back until the pressure became so great that sometime in July 2021, they all broke and they did whatever they wanted, the government wanted. So I do think that the pressure question is how much. And if it's really, if the government says we're doing a whole of government to shut down this message, I think you're going to have a lawsuit and I think you're going to win.
That's a good news. Pardon me for asking a stupid question. I'm asking it on purpose because I'm sure you heard it many times. But what did you answer, or do you answer? What happens in a case of a public health emergency when people argue we had to do it because it was a question of life and death?
So I differ with some of my clients about this, so I'm going to just separate that. I have a client in a case we brought previously that got dismissed, and why we were asked to join this one. Mark Changizi, he always says I'm a softie on the government. because I've always felt that the government, when an emergency hits, should have about 30 days to figure out what's going on. And I rarely blame them for 30, 60, 90 days. I don't really think you can always get action unless it's really bad. But he said, look, this is a respiratory virus that travels through the air. We all knew that none of this stuff was going to work because that's not how you do respiratory. And Jay said that too. Jay knew immediately. So I think the message here is that what the government can do, they're allowed to stop traffic with the outside world. They are allowed to do that. That's not a First Amendment thing. But they're not allowed to shut down the First Amendment under any emergency. It's just not a thing. The only thing that I can think of is wartime. But there's no part of the Constitution that lets you shut down the First Amendment. Now in Europe, there probably is. You can, but here you're not supposed to do that. So as far as quashing messages, I don't think that's ever allowed. And I think it's bad because what did it do? Nobody was worried about the CDC 5 years ago. Nobody was worried about HHS 5 years ago. Now, tons of Americans don't trust them. I always tell the story, the first inoculation of American Army was George Washington, and he ordered the smallpox inoculations to the whole Continental Army so that they wouldn't die, and they didn't die. But, you know, he was George Washington. Everybody trusted him. There wasn't like, oh, no, I'm not going to get inoculated. It was George Washington. But now the government agencies, the health agencies became, because they said things that people knew weren't true, and Fauci admitted this. There was no reason for 6 feet distancing. The cloth masks weren't doing anything. And the first time they stopped masks, it was because they wanted to keep it, the NT5s or whatever they're called, they wanted to save them for healthcare workers, so they lied about their efficacy so the shelves wouldn't clear of them. Well, that doesn't do anything. But if you say true things, and if you say what we don't know, and you're clear, look, we don't know, but we think this, people are more likely to trust you. And when you lie every day, and there's a bunch of scientists around who can say that that's not true or there's counter evidence, it just sows fear and dissension in the population. And that's why you don't let the government censor because it's an emergency.
Right. We have another question. Yeah, 2 more.
I don't know, John, hi, I don't know if you can hear me.
I can.
Oh, fantastic. It's very nice to meet you. I don't know anything about you because I didn't know that you were going to appear. So my question is, I wonder whether your view of what you were doing in this sort of area of law, especially before 2020, and whether 2020 and 2021 kind of changed you as a lawyer. I imagine you're a lawyer, and or as a person, whether it changed you, or whether you were already sort of very heavily involved in this kind of law before.
Just 1 second. Toby, does your question relate to this or not? No. Okay, go ahead.
I'll give you a quick, I was what I'll call a regular lawyer for about 20, 25 years. So I was on the defense side. I did some white collar criminal defense, and then I did commercial disputes. And then when I had my own firm, I sued the pharmaceutical companies over side effects for many years. But I became president of a nonprofit like this one that sued the government over violations of law in about 2016. Mm-hmm. So I became vice president, then president of that, and I had we did freedom of information requests to the government. I did the Clinton email destruction case that was a FOIA case because under the Freedom of Information Act, all these records are supposed to be preserved and they disappeared. So I had that case. I did not have as many free speech cases because they really hadn't come up. It was more agencies doing bad things. And so the case I started there and then brought here, that's famous here in America, was called Loper Bright and Relentless, and it had to do with how agencies could declare the law. And in 2024, they said they can't, that only Congress can. So I'm kind of known now as a Supreme Court constitutional lawyer in administrative law. But how, to answer your question, I had already started suing the government 4 years before, but the size and scope of the First Amendment violation that were revealed when we started this, when I just started it before, because this case, Murthy v. Missouri, was not our first case. Janine and I did the Changizi case, dismissed also for standing because they said, well, we don't know if it's social media companies or not. Well, you know, that's why you depose them. Ask. And Mark Zuckerberg has admitted it. Elon's admitted it. They've all admitted we came to the pressure. But of course, we didn't get that in court, did we? We got that after the fact. So I think that I was already suing the government. But this First Amendment, the attacks on the First Amendment, two things have happened. First of all, I found that young people in the United States are, when I was in school in the 80s, all the young people were for free speech. There was none of this misinformation, disinformation, oh, I'm all scared stuff. And now the young people are all like, oh no, we gotta shut it down or my ears will be hurt or something. So I do think that the change in the population amazed me, but also the government's brazenness amazed me. But I'd already been suing the government and not trusting them beforehand.
Okay.
Thank you.
Toby?
Yeah, thank you very much. Thank you very much for participating, John, in this discussion. It's very interesting. I have a question about, well, you said that the legal opinions have been that it's the biggest infringement of the First Amendment outside wartime. But I wondered what the comparison was actually to World War II. So how did the First Amendment sit in World War II and what kind of censorship did take place there? I'd be interested in that. And my second question, what I wasn't clear about from the ruling is if government can't pressure social media companies to censor speech, but can social media companies themselves do that? What was the outcome there? Because obviously there's been a lot of discussion around Elon Musk's Twitter and it's changed, and so I'd be interested to know how that's set.
That's an easy question in America. They can do whatever they want. The government can't tell the New York Times what to do, and New York Times does not have to print your letter to the editor telling them why they're wrong. They don't have to, right? It's like, if you have an English accent, I'll say, neither does the London Times, right? So the London Times just has to, it says, well, we don't want this person sending his letter in, and we're going to put it in the bin. So I think that is pretty clear, that they're allowed to do what they want. And the concern there is, of course, that they're all going to be owned by the same type of people, so they'll quash the same kind of messages. But that is not something I can attack legally against the government. I can't say the government's doing it. But in wartime, there are a lot of cases, and I would say World War II, there was less censorship than there was in World War I. World War I, I mean, they were throwing people, they were grabbing people off the streets. They weren't allowed to speak German. I mean, I'd say World War I had a more, a bigger crackdown on speech than World War II did. Because also in World War II, we didn't have a lot of protesters of any kind. And World War I we did, so the cases are more well known to American law. But we didn't really do comparisons just because the courts are pretty clear that with a declared war, there's a lot going on that they're gonna. It's not so much they say you don't have free speech. They say we're not going to intervene in the political process during these wars. That's really what they say.
Any other question? Yeah, many more questions. Alvin?
Thank you. I'm not a lawyer myself, so I hope it's not going to be a stupid question. But hypothetically speaking, can social media companies use your lawsuit to protect themselves against any form of other government regulations, such as the spread of racist, pornographic content, etc.?
This is a great question, because I think if I were the chief legal officer of Facebook or Twitter and government came to me, I'd be waving this around like it was going out of style, right? So they have a couple of things. They also have, and the current administration has a lot of free speech problems lately, but on social media it said it's issued what's called an executive order that none of the agencies are supposed to be doing this, except I guess the FCC. But anyway, they've said they're not going to do it themselves, and now we have these orders, and we have another order that's very similar against the State Department. In another case, Daily Wire and Federalist, which were two news sites, newspapers really, but online, that were shut down. And we have a settlement agreement against them as well. I think all of the social media companies, plus the people who are censored on social media, can wave these things around now and say they're precedent and say the government shouldn't be doing it. And I think the government's going to have a hard row to hoe, saying, oh, that only applies to Vecchione's clients, Louisiana and Missouri, right? It's going to be very hard to hold it just to those things. The problem for anyone who gets upset about it is they got to bring a suit. It's not like me, who I can just say, look, I've already had the suit, here's the order, enforce it. So there's no silver bullets, but it's a huge advance to what we had in 2019, 2020.
Anybody else? So I have one last question, maybe if you're last. I don't even know how to formulate it because I'm not a lawyer either, but I found the Supreme Court ruling on the lack of standing really disquieting. Like, if they couldn't find any standing in that case, I mean, how is that even possible? I mean, the standing was obvious.
Here's how it's possible. In the complaint, we noted that social media began curating messages like early in the pandemic. But then we talked about how it was ratcheting up. The Supreme Court did not like in my view, okay? Well, first, I'll take Amy Coney Barrett. She's very consistent. She wants a one-to-one injury. Like, if the government said shut down the speech of Jay Bhattacharya directly and told the social media to do that, you'd have standing. But that's not how they do it. They say, we think masks are great and we don't want to see all this anti-mask stuff. And I'll just tell a funny story about this real quick. But Biden was tweeting out some message about the vaccines, and it got caught in the algorithm that the government had made them all put in. And Biden's tweets were being downgraded and taken off the internet. So the White House called up all the social media, and I'm pretty sure it was, I won't say because I don't want to, because I've forgotten which one it was, but there's two guys who were particularly big at yelling and cursing at people. And one of them calls up and says, the president's message been taken down, how could you be doing this? And he didn't like being censored. He didn't like being censored in his own algorithm. But I always loved that story because they knew that message had been taken down because it had touched on some tripwire they'd set up with the robots. I think that the standing problem is a problem, but now I think our allegations are going to be better. I'm going to start with what I think the government censorship with is and not on the social media, whatever they were doing. Let the government allege that, and then we're in the fight and we'll get discovery on what the government did and what it didn't do. We're not going to give the court any idea. The other thing that never came up in oral argument, it's always really annoyed me because I didn't argue this. Jill Hines, who's one of our clients, she was a Louisiana activist and housewife, and she runs this organization concerned with parents controlling their children, what vaccines they get and what they do, whether they wear masks or not, that kind of thing. And one of her websites was just a little chat group that you had to be invited in and be one of these Louisiana moms. Now, Mark Zuckerberg, whatever his views are, has zero interest in cutting off a Louisiana chat group among Louisiana moms. You know who does? The government. So I don't think it was ever made clear on that one, because it really had oral argument. It all focused on Jill Hines, and I think that the motives of the social media versus the government was not brought out enough. Social media makes money off of eyeballs. They don't want to push eyeballs away. The government wants to push eyeballs away because they don't want those messages getting in those eyeballs. So that idea was not really grasped by the Supreme Court at all. But I think it will be next time.
Okay. Nobody else? Well, we can only thank you so much. Please say hello to Janine and thank you to her as well.
Well, and she does have a real emergency. That's why I took her off the emails because I knew she didn't want to be disturbed by them. But she's very regretful she wasn't here. But I'm glad I could pinch hit.
Yeah, thank you so much. Thank you.
Connected. It's all becoming connected. So we are learning from different crises. Thank you.
Any other questions?
Professor, you have your answer.
Yes, okay. There were two questions. Could we observe your question a paradigm shift? And your question is the concept of singular crisis a fruitful framework to analyze current geopolitical conflicts? My answer is clear. I'm a sociologist, and sociologist is a kind of social sciences, and we don't want to speculate into the future because future is an open horizon.
Yep.
And future is contingent, and we have different empirical methods and different theories to understand current societies a little bit better. And with our methods and behind a reflexive methodological view, it's not for me possible to answer this question regarding can we observe a paradigm shift. If we could observe future, we don't have a future.
I mean, I was thinking more theoretically. I mean, the theory of the paradigm shift. I don't know. For somebody who some of us know here, Daniel Hadas wrote an interesting piece about Kuhn and paradigm shift, and observing actually what happened for me was that medical history was passed away in favour of modelers who represent computation, and for me that is the paradigm shift, which I guess I saw. But so I'm not sure. For me, the question was about the future. I suppose that's what I'm saying.
With the question I was asking, there was one more specific thing, and I didn't explain myself well enough. These singular crises, these unusual crises where the indivisible debate can't just be managed back into divisibility, are there specific circumstances in which that will occur? Like, what do you see was specific about COVID that made it one of these singular crises? And would there be a more general theory of, in the future, a certain type of combination of things could lead to another singular crisis? Or do they just come out of nowhere unexpectedly? I guess predicting what would make a singular crisis at least might be helpful, so we can be looking out for things, if you know what I mean.
I think it's one point. I'm a sociologist and I'm not a historian. And when I talk about a unique crisis, a singular crisis, my special interest is to observe recurring social mechanism in such unique or singular crisis. And I present a table.
Yep.
And in this table, I differ between normal crisis and singular crisis along 7 or 8 different dimensions.
Yes.
And this was, in the sense of Max Weber, an ideal, typical differentiation.
Yeah.
And from the view of sociology, for me, it was not very surprised that culture clashed, that the horizon of epistemic views are going closer and closer, and that political institutions are not very open to discuss about evidence and non-evidence, and our interest is to identify recurring social mechanisms in such kind of crisis.
Yeah, I would like to again continue on this question, since to me it seems still relevant. We had in 20th century various flus, various pandemics, and none of them constituted a singular crisis, this unique event where different mechanisms came into play. Spanish flu, Max Weber died of Spanish flu 100 years ago.
And no one noticed.
Yeah, no one noticed, no one cared. And the young people died, prevailingly young people, millions of people, and it was not an event of historical significance which gave rise to this kind of reaction. Then the Spanish flu, Asian flu, Hong Kong flu, but then 5 years earlier, in 2020, the pandemic, which started like a normal respiratory disease, insinuated this kind of total societal crisis, which created a threshold, societal threshold. So what kind of conditions were in play that now and not before health crisis insinuated a societal crisis, societal transformation, unique, singular event?
In my view, in my strong sociological view, we have no objective indicators to identify a situation as a crisis or a non-crisis. For sociological thinking, it's fundamental. It's a famous Thomas theory. If man defines situations in a collective way as a crisis, we have a crisis, and the consequences, the cultural, the political, and the society consequences are real. There's a difference. The influenza, the flu crisis in the end of the First World War was a totally different situation. It is necessary that we have a collective agreement about the event as a crisis.
Yeah.
Oh,
Not
sorry.
so much asking question, but rather answering to this. At the time of the Spanish flu, it was right after the First World War. So anyway, so many dead people. And it was more like a continental crisis, not global. And I think it's now the communications technology and
Social mobility.
global traveling. I mean, if something starts in China, it cannot be stopped. And maybe 100 years ago, it could have been more isolated.
Any more questions?
Yeah, like more, and plus the Bolsheviks, like in the 1919, 1920, like Spanish flu is a big deal, but what about the spread of communism? That's the biggest disease they're facing now.
And a footnote to the international law, because you said that it is now crumbling, it's dead.
It appears to be.
Yeah,
As a
but we are
non-lawyer,
talking
observer.
about the international law, so it is not dead. It is broken. Some states don't keep the law, some actors, but it doesn't mean that the international law doesn't exist. It can reinforce the international law if some actors break it, because then they start a discussion about, and then people are more committed to keep the international law. So I am not so sure that international law is over.
That's why I was
So
asking.
your job is secure.
That's why I was asking about the EU. Isn't it legally
EU.
if we have some transnational body that has mechanisms to enact?
Yeah, but the end of international law is often mentioned with Israel and Gaza and Venezuela and Iran. So it's like a global collapse.
But I mean, don't we
That
have to be
was my
honest about
reaction.
this thing, international law? Surely international law was always simply a way to try and impose normative liberal values of Western democracies. I mean, and now if it's breaking down, it's breaking down because that normativity no longer exists.
Yeah.
It's not because anything has changed in international law as a field, as we see, because international law, as you basically told us, they will try and excuse anything.
Yeah, it's in perpetual crisis. That's actually not an exception. Like international law I've been studying it for 20 years. It has always been some crisis. Like all the time we're saying, yeah, it's dying, but it's not. So that's the paradox is that there is no paradox. And I have an article saying symbolism is the main purpose of international criminal law. That its main purpose not to try perpetrators, but symbolic, to say rape in war is not okay. Like this is what Yugoslavia Tribunal said. Because before the Yugoslavia Tribunal, rape was considered to be spoils of war, and it was considered to be normal.
Really?
Yeah. Comfort women, but yeah, soldiers have needs when they go fight.
Oh God.
Yeah, but Yugoslavia Tribunal really changed that, and Rwanda Tribunal. So for that, we have a new discourse formation, and we have a new standard, and like this we unfold. But sometimes it becomes a bit dramatic. So now we live in a very dramatic, value-changing system. So yeah, we'll see where it goes, but it will not die.
Questions? Young man.
Professor, a few years back, I was also at a panel where you talked about the same topic. Since then, are there some views that changed or some new ideas that came up to this day when you held your presentation again about this topic?
My new focus is to better understand the dynamic of cultural conflicts during the pandemic and the link to the kind of production of knowledge and the institutional consequences regarding learning or unlearning processes. In my view, the new argument is that we could better understand the crisis of Corona if we analyze the interconnection between the cultural order, the order of knowledge, and the political institutional order. And this was a step that I have presented today. But I come back to my old thesis that the central push factor for a better understanding of the collapse of, in my view, of the collapse of a good policy is the collective morality and the central push factor is culture for me. It's a cultural sociological interpretation of the Corona management.
Okay. More questions? Comments? Okay, so then thank you. And
So I guess we can